Good morning, everyone. Welcome to the First District Court of Appeals. We have 3 cases for argument today on our docket, and 2 have been submitted. I'm going to read the cases, and if the attorneys would please identify themselves and their readiness to proceed. The first case up for argument is Reeder versus Reeder, and that is case number C220631.
Yes, Your Honor, Ms. Andre sat here on behalf of Michael Reeder.
Good morning.
James Moskowitz on behalf of the appellee.
Good morning. The second case up for argument is In Re SD, and it's case number C220603, 604, 605, and 606.
Jessica Maltz on behalf of the appellant SD, ready to proceed.
Good morning.
Paula Adams on behalf of the state of Ohio, ready to proceed.
Good morning. And the final case for argument is State versus O'Neill, C220541.
Phil Cummings from the state of Ohio, ready to proceed.
Good morning.
Sarah Nelson on behalf of Mr. O'Neill, ready to proceed.
All right. So if the parties or the attorneys, for Reeder versus Reeder would step forward, we'll start with that one. And Ms. Reset, would you like to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 4 minutes.
4 minutes. I'll be using the lights on the podium. When you have a minute left of your initial time, the yellow light will come on, and the red light means you're at your time.
Thank you, Your Honor. May it please the court, as I said, I'm Ms. Andre Sat, counsel for the appellant Michael Reeder, who's here with his father and brother. The trial court in this case made a decision as to one issue, the disposition of one fertilized egg. In deciding the disposition of that tiny egg, the court unleashed the possibility of havoc for many lives by upending the agreement reached by the parties as to what would happen with that embryo. The parties had a relatively short marriage of about 5 years, and during that time, they sought the assistance of the Fertility Wellness Institute and underwent in vitro fertilization treatment. The treatment created a successful pregnancy that led to the birth of their child, Ansley. Samantha filed for divorce 3 months after Ansley's birth. At the time of the trial, that embryo was really the only issue for decision. The parties had otherwise reached agreement on all other assets, debts, and parenting issues, and so the case proceeded to trial on that basis. Samantha wanted to use the embryo to attempt to achieve pregnancy, and Mike objected to that. The trial in the underlying case focused on that issue, and there was only one exhibit admitted, which was a consent to cryopreservation and storage of embryos, what I'll refer to as the agreement, which set forth the couple's agreement with the fertility clinic as to the terms of the IVF process and the agreed upon parameters for it and the use of the embryos that it created. The trial court applied the contractual approach to this issue, the approach that's used by the only other Ohio courts, to have addressed, the only other appellate courts, I should say, who have addressed this issue of what to do with a frozen embryo at the end of a marriage. Our first assignment of error is that the trial court erred as a matter of law by interpreting the agreement to allow the use of the embryo by one party over the objection of the other to achieve a pregnancy. Simply put, the issue is that the trial court erred by ignoring the clear language of the agreement, providing that the embryo could not be used to achieve pregnancy over the objection of the other party. As the court's aware, this is reviewed on a de novo standard because it involves the issue of contract interpretation, and this court is obviously in the same position to be able to do so.
Counsel, how would a party register their objection under the contract?
It did not specify how a party would do that. Presumably at the time, the party could do so. There was no specific provision within the contract, and I think you're raising a good point that to the extent the trial court basically said by signing a statement that said a court may at some point down the road make this determination that Mr. Reeder had effectively consented and would not register any objection, but you've rightly noted there was nothing in the contract by which he could note that he objected to this going forward.
And then on the flip side, how would a party register their consent?
Well, a party could certainly do so at the time. We believe that the clear implication here, you'll note that there were multiple scenarios envisioned of what would happen if X, Y, Z, you die, we discontinue, etc. What's most relevant here is that the options provided in the event of divorce were 3. Number 1 was to dispose. I'm not doing them in order, but the number 1 was the one that was chosen. But 2 and 3 were to dispose or donate. That's relevant here because, in our view, the intent of the provision the parties selected, meaning that at some point there would be an agreement or court order provided, was simply meant to provide the parties with the opportunity to review the matter when the situation actually occurred. Because otherwise you were immediately choosing to dispose or to donate the embryos when perhaps, depending on how things proceeded at the time, this is a contract you're entering at the time that you're starting this process. And so at that point, you don't know if you have been able to generate at least one pregnancy, if you are going to remain together, etc. And so I believe the clear interpretation here, when you look at the various points in the contract in which the parties were assured that there would need to be consent before achieving pregnancy. Certainly, if the intent was for the language that by checking the box of allowing a court order or agreement to achieve pregnancy, if that was intended to mean consent, our position is that should have been spelled out clearly, and it was not. And so to your point, there was nothing in the agreement specifically that stated, check here if you object, check here if you consent. And therefore, it is clear by the terms of the agreement that checking of the boxes at that point was not intended to provide that consent. That was something that was considered to occur at a later point. And that makes the most sense if you consider how these things are likely to proceed. It puts the court in a position in order to determine at the time that the issue arises, was there consent? There's no dispute between the parties about who checked what, did they mean it, did they not? The court would be able to determine, is there an objection, is there not, do both parties consent? And therefore, let's not lose track of the fact that at the end of the day, this contract is really intended to benefit the fertility clinic, frankly, to protect them from potential liability.
Counsel, can we pause there for just a minute? So It's the Wellness Institute that needs to be notified of the consent because they're the entity that is in possession of the embryo and that will be releasing the embryo for some medical procedure in order to both thaw it and then implant it, correct?
That's correct, Your Honor. In fact, the language specifies that the court order, or that the decree or settlement agreement will be presented to them. So presumably there is we would use the notice, that it's service of some sort, but basically that there would be a presentation of that agreement or that court order to the wellness clinic so that they would be able to proceed.
All right, and I recognize that this is somewhat uniquely postured in that we typically don't think about another entity as being involved in a party's divorce. But is the Wellness Institute necessary? Do they have interests, legal interests that we need to consider in this proceeding?
I think they might, but they obviously were not party to this particular issue. I think we're the parties to the extent that this is seeking to clarify and authorize them to release and allow the implantation of they are storing the embryo. So it's certainly understandable that the wellness clinic wants clear direction from either the parties, or if the parties are unable to provide that clear direction jointly, that it wants direction from the court. And as part of that, one would envision that the Wellness Institute would want to make clear that to the extent that its contract throughout is replete with the representation that pregnancy will not be allowed over the objection of another party, that there would be a court decision that would provide that that had occurred.
And does this court decision provide that?
If this court were to determine that that wife is entitled to proceed, then wife would be entitled at that point to provide the order as requested. Now, as I said, the Wellness Institute may have its own objections or its own issues. It's a third party that has not been subject to this matter, so it may well have additional issues that it may wish to raise. But for purposes of as between the two parties, that would be something that complies with the agreement in terms of providing them with an order to do so.
And I realize that this may be somewhat outside the record, but do we know if the Wellness Institute has even been notified that this dispute is going on?
Again, that's outside the record. I will represent to this court that I'm aware that Mr. Reeder has advised them that he objects and that he is appealing the matter.
So per this contract.
And I will say, in addition to that, Your Honor, there's a stay that's been in place, as you're aware, at the trial court. Yes, Your Honor.
Per this contract, if we were to agree with husband, what would this just fall under the default disposition of the contract?
Correct. It could be either in the default, or husband is certainly willing to say that if he is provided with the embryos, he would dispose of them, but only for example, he would not use it to achieve a pregnancy without the consent of wife. But under the circumstances, there is a default provision that provides that if neither option is available, i.e. if an option to achieve pregnancy is not available, which in this case we would say it is not because there's been an objection, then I think the wellness clinic is within its rights to at that point dispose of it per the default provision that you're referencing.
So are you saying that this particular contractual provision where it says that a court decree or settlement agreement will be presented to the Fertility Wellness Institute directing use to achieve pregnancy in one of us contemplates that potentially the husband could get the embryo?
Yes. I mean,
how would
obviously with
pregnancy?
with a subsequent partner. I think otherwise it renders the language meaningless
in
unless
one
you're
of
dealing
us.
with a lesbian couple.
Well, right. That's what I was wondering.
Right. So I was going to say, I believe what it anticipates is, for example, there may be a scenario down the road where the parties might agree that they want to have another child, that they might want to use the embryo to achieve another pregnancy, but there may be a dispute as to which party wants to do that. Mother wants to do that, father wants to do that with his new partner or a surrogate. There may be circumstances that would be associated in that regard.
Okay.
Let me ask you a question. I know this is generally a contract or is a contract dispute, but what are some of the legal ramifications for Mr. Reeder if former wife is permitted to obtain the egg, have it implanted, and have a baby?
I think that's the issue, Your Honor.
Yeah.
Obviously,
What are
the
they?
position in which he is placed is that he would be in a position where he would have to either forfeit his parental rights to this child in order to be removed from all the financial and other obligations, inheritance rights, all the other terms that come in. He'd either have to forfeit that or be required to be a participant with his ex-spouse now in parenting this child. And the court in I'm going to butcher it, but I'm ruining it. The Paul case. We'll call it the Paul case. It was referenced in our case.
Yeah.
Kind of envisioned that. It's not, frankly, science fiction to try to imagine what would happen. Imagine if he were to go to exercise the parenting time, which he has. He has significant parenting time for Ansley, the current child. What's he going to do? Pick up her and then her new sibling, who is also his genetic child, his biological child, by all other means his legal child. He's going to be forced to say, oh, no, not you. I'm just picking her up and I'm going, how does that play? The Paul case, I won't try Kotwaski again, the Paul case there kind of envisioned that. You're putting him in a position where over his own objections, he's having to do that. And this is something that he relied upon in the contract. Even in the testimony in the record, he stated that that's the basis on which he decided to check the court decree that at various points, and the court acknowledges, yes, that is part of the contract, is that it would not occur over your objection. But by saying, what the trial court did is say that by checking that box, which does not say, I hereby consent to a pregnancy, period, unless I otherwise object to it at a later time, because recognize that the way the contract is written, both parties would then have to amend it with another executed document that would say, we revoke this, et cetera. So effectively, what the court is saying is that by checking that box, I've effectively irrevocably consented to this, because unless I get my wife to also agree that I object, which of course, logically speaking, you're not going to be in this issue if there's agreement by both parties as to what should occur. It renders it senseless, frankly.
Well, and counsel, isn't the purpose of a divorce to disentangle the relationship between the parties, not create a new one?
Absolutely. And Your Honor, this flies in the face of that in the most personal and direct and frankly egregious way possible. This is a situation where 3 months into the birth of the first child, wife chose to leave the marriage, which she's of course entitled to do, but to now push that she should be allowed to create another relationship long after the marriage has ended, long after the court has attempted to disentangle these parties. They were already obligated to deal with each other for the sake of the child who is born, and to now require that over the objection of husband is really an untenable position to put him in. At a minimum, if that is what this court is going to require and impose, it should do so on the basis of crystal clear language. And as I said, in this contract, the contract is clear again and again and again that this will not occur over your objection. And so to simply say that by checking a box that effectively said, I'm not prepared today to immediately agree that everything is donated or everything's destroyed. I'm not making that decision this minute. I'm going to push this issue off. I think that is the most reasonable interpretation here, given all the recitations in the contract that say, and specifically that says, in the event of a divorce, if you terminate your marriage, you will need to consent to a pregnancy in your ex. That is a scenario, again, that frankly, the court went too far. The court, on the one hand, acknowledged the language that was in place, but then it ignored it entirely by saying that by checking this box, and again, it's a form document, the parties didn't choose this language.
And if you want to reserve some time, unless my colleagues have additional questions, I just wanted to let you know you're a little bit over where you were.
Then I will, unless there are other questions, I will reserve my time for rebuttal.
Okay,
Thank you, Your Honors.
Mr. Moskowitz.
Good morning, Your Honors.
Good morning.
May it please the court, this case is not about religion. It's not about morality. It's not about right or wrong. It's not about the Constitution. It's not about civil rights. It's about words. It's about a contract between a husband and a wife, a contract that the evidence shows was entered into freely and voluntarily, willing and with full knowledge. It is not a court's place to jump in and protect someone from themselves if the court deems it appropriate. The questions that were asked about the ramifications of this contract, what it means if you have a child after you're divorced because of IVF, irrelevant. This is a contract case. And the contract could not be any more clear. And I just listen, I've read briefs and now listen to an argument that contorts everything to say what the appellant wants it to say. When you read this agreement, it is clear. All of the language that is being talked about that cautions people, we cannot do something over your objection. It's a preamble in the contract. It's the first 2 pages of the contract. It is letting the parties know their rights and obligations. And then the contract specifically says, to move forward, we need you to tell us, and I'm paraphrasing, we need you to tell us your intention. And one of the intentions is, tell us what to do if your marriage is terminated. And these 2 people did not check the box that says, destroy the embryos. Did not check the box that says, donate anonymously. What they did is they checked a box that said 2 things: that a court decree, number 1, and or settlement agreement, number 2, will be presented to the Fertility Wellness Institute directing use to achieve a pregnancy in one of us. What does that mean? It means what it says. It's either an agreement to them or it's a court order directing what's going to happen.
So it means that they can go to court in a divorce and fight this out, and one of the 2 of them could get awarded the embryo and use it to achieve pregnancy,
That's correct. That is
including husband.
their agreement.
It's
That-
not just saying they go to court on a divorce and the wife gets it.
No.
It could be either one of them.
Directing, but there's another part to that. It must be used to achieve pregnancy. That is the language they agreed to. Now, at trial, the testimony from father was he's not going to use it to achieve pregnancy.
So by default, mother gets it.
She's the only one who testified that she wants to use it to
What
achieve
if neither
pregnancy.
of them wanted to use it?
Then that could potentially be an agreement. So when you read this contract, it says over and over again, I think in 4 different places, that by checking the box, you are telling, again, I'm paraphrasing a bit, but it says over and over, by checking the box, you're telling us what you want to do. If you guys, by agreement at a later time, want to change this, you can do so by agreement in writing. It says it over and over again. If it had flashing lights, it would have it in there saying, by checking this box, you are telling us what you want to do. It's everywhere, making it clear that checking the box is your intention of what you want to happen, and that intention can only be changed in the future by a written agreement.
What I don't understand is why you're saying that the language at the beginning of the contract doesn't apply when we're interpreting the rest of the contract.
I didn't say it doesn't apply. I said it's a preamble. It is setting forth, it's letting the people know,
Yeah.
hey, by the way, here are your rights and obligations. And one of your rights, before you sign this, you need to understand without an express agreement between the 2 of you, you cannot use this to achieve a pregnancy in the case of a divorce. They are
Right.
telling you that, and then they say, okay, 3 pages later, now in the event of a divorce, what do you want to do? Now that
Counsel,
Yes.
can we address your preamble argument? I mean, I'm looking at the specific language that I think you're talking about, and it's not under a heading that says preamble, it's under a heading that says disposition of embryos.
Yes, and
It identifies 3 alternatives. Number 3 is use by one partner with the permission of the other to achieve pregnancy. And then
Correct.
down at the bottom of the page, under a separate bullet point, it says embryos cannot be used to produce pregnancy against the wishes of one of the partners. So is it your position by checking the box for court order or settlement that those provisions are just erased?
may I point something out? It actually doesn't say what you just said. It actually says it cannot be used to create a pregnancy without the express written consent of both parties. It doesn't say over the objection. It says without the express written consent, and that's what I'm saying. Then on 2 pages later, it is asking for their express written consent by checking the box, and then 3 pages after that, signing the document. And it says, when on the last page, above where they sign, our signatures below certify the disposition selections we have made above We understand that we can change our selection in the future, but need mutual and written agreement as outlined above. Again, right before they sign, they are being told by signing this, the box you checked is your agreement, and you can only change in the future if you both agree in writing to do so. There is no confusion here.
So your argument is that by checking this box, that is the express written consent?
That's literally what the contract is saying to them. Check the box to show us your agreement. Now, if you do what is being argued, you are rewriting the agreement. Like I said, the box they checked, there's one choice. That is to achieve a pregnancy. Mom said, I want to achieve a pregnancy. Dad said, I didn't. Easy. Evidence shows the person who said, I'm going to comply with the contract wins. The person who's not going to comply doesn't.
What if they both want the embryo in the divorce?
Then that's why it says a court order or agreement.
So the
They
judge gets to then
agreed.
decide who gets to.
Crazy, right?
Yes.
Yes, it is nuts. I agree with you. The contract.
You think this contract's crazy?
I think it is clear. But it's crazy to me because I wouldn't want to sign to do that. I have not been
It
in
would
that.
be kind of crazy if you divide up all your property and then both parties want the embryo and the judge gets to pronounce who gets it.
What's crazier to me is someone would sign a contract that says, here's what I want to do in the case of a divorce that is something other than complete separation, but that's what they did.
But if you read the front part of the contract in conjunction with it, then you would need consent.
No, if you read what I believe happens when you go down that road is you are now rewriting the back end of the contract. Exactly the
Or it makes the contract less crazy.
No, it doesn't at all. The idea, you are allowed to agree to dumb things. People are allowed to do it. It is not the court's job to step in and say,
What I'm
"That's
saying
dumb."
to you is that if you read the contract as a whole and you read the first part of the contract in conjunction with this box, then it's not crazy. It's not dumb because it says achieve the pregnancy in one of us, obviously, as long as one of the parties consents.
And I will ask a rhetorical question and let you kind of ponder it.
Please do.
If it means what you say, what's the point of the
I'm not
checking
saying,
box?
I'm just saying that that's what the other side is
I'm
arguing.
saying, if you go with that, what's the point of checking the box? Nothing. It's irrelevant. It means nothing.
Could it be
What's the-
what counsel just argued, that the parties didn't want to determine at that point in time that they wanted to destroy the embryo or donate it, and they wanted to have potentially the opportunity later to decide if they wanted one of them to be able to use
There
it?
is nothing in this contract, nothing in this contract that even supports that. There's nothing in, it is, like I said, it is clear. They checked the box. They've been told over and over, including right before they signed, that was your selection and it can only be changed in the future by a written agreement. They did not have a written agreement in the future to change the selection. Therefore, their agreement gave the court the authority, because there wasn't a settlement agreement, it gave the court the authority to award someone the embryo pursuant to the terms of the contract, which is to achieve a pregnancy, which mother was the only one to testify she wanted to do.
Counsel, this contract was prepared by the Wellness Institute, right?
Yes.
And so it, in theory, contemplates a variety of people's situations.
Sure.
And from the Terrell case in Arizona, we at least have a model for why parties might agree to postpone a decision and why there might be consent to allow a party in a divorce situation to implant a frozen embryo. And that might be because someone has a very unique health situation that precludes them from ever having children if they don't use that one embryo.
Well, the Terrell case is different from this case because that contract specifically said you had to have a contemporaneous agreement. And what the court in Terrell did was say, because it says contemporaneous agreement, we're going to take its words at face value, meaning at the time you want pregnancy, you need an agreement.
It is different, but it does help us understand why a contract might have a box like this, because in Terrell, the mother had a serious form of cancer that took away her ability to ever have children again. and freezing these embryos was her only opportunity to ever conceive a child. And so that might create a situation where a couple might say, in the event of divorce, we would consider in the future agreeing that a party, even in the event that we divorce, could, with the consent of the other party, use this embryo because they would never be able to have biological children.
Sorry, I didn't originally understand what you were saying. Yes, I agree with you, but again, that kind of requires a delving behind the words of this to ask the why, which I don't think that there's any ambiguity in this agreement to do that. I do think everything is in harmony, and I think it's in order, which is the best, because if you read this contract in order, there is no confusion, there is no conflict, there's no ambiguity. I think I would have a much harder time making this argument if the words upon which appellant is relying actually showed up within the box that they're checking or after that. But it doesn't. It's laying it out ahead of time.
But could a person rely on this language in deciding and making their choice among these three boxes? I mean, if you're reading this contract in order and you see this language, embryos cannot be used to produce a pregnancy against the wishes of one of the partners, and use by one partner with the permission of the other to achieve pregnancy is required, would you rely upon that in checking the box? Would you think, oh, the other person's not going to be able to use this without my consent when you chose that option?
So I think that is a disingenuous argument because it ignores all the other language in the contract. So that argument ignores the multiple times this says, by checking the box, you are telling us what you want to do, and it can only be changed in the future by a written agreement. That argument ignores that and says, hey, that language doesn't mean anything. What's more important is all the other language. And oh my gosh, I just didn't understand. Well, there's no testimony about learning disabilities. There's no testimony about mental health issues. No testimony about that. This language is not confusing. It's not legalese. It's not complicated. And when it says over and over, by checking the box, you are giving a consent that can only be changed in the future, it really makes it difficult to make a credible argument that says, well, I thought I could change it in the future on my own, unilaterally. That ignores all the different places where it specifically says you can't do it. And that's what they're asking you to do. They're asking you to declare that the father in this case can unilaterally repudiate the contract and say, I don't want to do it. And there is no default that the court raised. The default was if what you choose is not obtainable, I'm sorry, I don't want to paraphrase. The default says, in the event none of our elected choices are available as determined by the Fertility Wellness Institute, the Fertility Wellness Institute is authorized without further notice to us to destroy and discard our frozen embryo. It doesn't say, well, if you guys can't reach an agreement in the future, then we can do this. It says, if it's not available as determined by us, not by a court, not by anyone else.
Well, I mean, if the contract were read the way the appellant is asking us to read it, then the court would have to say neither party gets the embryo, right?
I don't think the
is it
court
somebody
could say
gets the
that.
embryo but they can't use it? Is that
I don't
the
think the
answer?
court could say that you would be rewriting
okay.
their agreement.
Well, so we have two issues though. We got the court, somebody gets the embryo and whether somebody can use the embryo, right? So what if the court ruled you get the embryo but you can't use the embryo?
No, I don't think the court has the authority to make that order. The parties made an agreement.
But I'm just saying, what if the court did that? And that was the court order.
I think
And then
you
the
would be running
Fertility
afoul of the
Wellness
contract.
Institute would, I mean, I don't know, what do you do with the embryo at that point?
Well, so if you're asking me to stand in the place of Fertility Wellness Institute, I think if they rely on, if the court made that order and it wasn't appealed and the appeal time ran and that was the final order, as far as they're concerned, if I'm advising them, they're probably protected but that's
Right.
not really the issue at
But
hand.
that goes to the default disposition, right? It's like, if there's a court order that says that, and then they have this court order, then they get to decide what to do under the default position.
If you want to ignore that the parties agreed that the only possible disposition upon divorce is an embryo to one of them to achieve pregnancy, and you want to ignore their written agreement, then you can do that. But their agreement is what it is. That's why I'm saying this is about words. This isn't about right or wrong or how we feel or what is this a crazy result or not. It is their contract, and they were free to make it. The contract terms of, in and of themselves, they're not outside the bounds of public policy. As Your Honor pointed out, there could be plenty of reasons why people agree that after we get divorced, one of us can use an embryo. And it's not our job to look behind this to figure out, well, why? What are the different reasons? The fact that they exist are enough.
Counsel, is the Fertility Wellness Institute a necessary party? I mean, looking at the default language, for example, the Fertility Wellness Institute gets to determine whether the elected choices are available, and they get to decide if they're going to destroy the embryo if the choice isn't available. That's in their sole discretion. So I could envision a situation where they say this court order isn't sufficient because husband is still objecting to pregnancy. There's this other language in here. We're not going to implant the embryo. And then your client is suing the Fertility Wellness Institute for breach of contract or vice versa. Should they be a part of this proceeding?
Well, I really think going into the proceeding, it was a determination of who's getting the embryo. I mean, at its core, it's a contract, and that's what the contract says. One of you is getting the embryo, who's it going to be? And that's what it was. It's now morphed into this odd thing that the contract doesn't actually say what it says, and if you take language on page 1 and apply it to page 5, it changes the whole meaning. I really don't think that was the case before the court. The case before the court was who's going to get it. That's what you guys agreed to. One of you is going to get it to achieve pregnancy. The idea that there's anything else to this is just fabricated, and you know, I suppose perhaps if you are saying that the terms of this contract are somehow invalid or vague, I don't know that what happens in this case really impacts any other case, any other clients that they have, where they would have to be a party. I don't think the ruling in this case would trickle down to every party that signs an agreement with the Wellness Institute.
Mr. Moskowitz, unless my colleagues have any other questions, you're at your time.
Okay, thank you very much.
Thank you. Ms. Teresa, I'll give you 3 minutes for rebuttal. You were a little over, but so was the other side. So.
Thank you, Your Honor. Very quickly, the Terrell case is the appropriate case to look, and I want to direct the court in particular. There was one provision in which it referenced contemporaneous consent, but more importantly, Your Honors, the specific language about embryos cannot be used to produce pregnancy against the wishes of one of the partners, and in the event of a separation, it cannot be used without express written consent is exactly the same in that case as in this one, and the court addressed the issue, and only one of the 3 reasons why it determined that checking the box was not that express consent relied on the contemporaneous consent. So I want to direct the court to that. More importantly, this is about the words, and in interpreting this, the court is required to give them their ordinary meaning unless manifest absurdity results. Again, you've highlighted the exact provision. The parties read through multiple points saying you will not be forced to have a child with your ex over your own objections. What these words do not say is I am hereby consenting to pregnancy, to achieve pregnancy, even if at the time I dispute that. It is simply saying that the court can review the matter at the time to determine if there is agreement, if there is not. Frankly speaking, given that I do this type of work all the time, there are a multitude of scenarios where the parties may not even have an objection, but you can't get a party to do the thing they need to do, to sign the document, to get the order, so that you go to court doing it just recently. There are circumstances where you have to go to court to get the deed to transfer the property, even though everybody agrees it goes to it, but the one party hasn't complied with it, hasn't given the documents, et cetera. It's just as easily that could occur in this case. And so, again, you are required to avoid manifest absurdity. You said it yourself, Your Honor. This contract is crazy if what it says is, by checking this box, I'm hereby standing and saying, till the end of time, over my objections, you are welcome to proceed ahead. It makes the contract crazy, and this court's interpretation is specifically required to avoid that result. And the only way to do it is to read into it the full language of the case, the full language of the contract, which says, recognizing that if there is an objection, the court will not make such an order. You nonetheless authorize the court to make an order if one is required. And likewise, to your point, Your Honor, it avoids the ridiculous circumstances in which we find ourselves, where despite the obligation to disentangle the parties, we are imposing either a great deal of legal requirements over a party who does not wish to have them, but more importantly, putting him in the untenable position that the only way he can avoid those is to shun his own biological child, an untenable position. And for that reason, Your Honor, we ask that this court not read the contract in a fashion that makes it crazy, but in fact read it as the parties here did, which is to say, this is something that will not happen over your objection, and you're simply authorizing the court to determine that. Thank you, Your Honor.
Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Thank you. The next case is In Re SD. And Ms. Moss, would you like to reserve some time for rebuttal?
Yes, ma'am. To reserve 3 minutes.
3 minutes. Whenever you're ready.
Good morning, Your Honors. Ms. Adams, may it please the court. Jessica Moss on behalf of the appellant SD. This case is about whether the juvenile court had subject matter jurisdiction to issue a Tier 2 classification on SD at the time they issued the classification. Now, 3 dates are important here. October 31st, 2022, which was the date of the hearing, and the date that court put on an entry that did not include a classification. The next date is November 1st, 2022, which is the date that SD was released from incarceration. And October 2nd, 2022, which is when the juvenile court issued the non-pro-tunc entry that imposed the Tier 2 classification on SD.
So the very first entry, what was included on that one? I mean, was that everything but the classification?
So what was included in that one, the main hearing was about whether or not to invoke the adult serious youthful offender sentence. So
Okay.
that entry determined that the court was not going to impose that adult serious youthful offender sentence and ordered the SD be transported from Department of Youth Services to the Hamilton County Justice Center, which he would then be released from subsequently.
And that was on time.
Correct.
The court immediately filed that.
Correct.
Okay. And so, and my understanding is at the hearing, the court imposed the Tier 2 registration, right?
That is correct.
Okay. And so basically inadvertently left off the order that was timely filed, this Tier 2 registration.
Yes.
Okay.
So yes, on November 2nd is when this non-pro-tunc entry happened, imposing classification that also included the explanation of duties to register. So that also was not included in the October 31st entry.
Okay.
And kind of this issue is, the assignment of error is broken up into 3 issues. The first is just whether or not the juvenile court has jurisdiction at all to impose an initial classification after a person has turned 21 and after they have completed their disposition. And to get to this answer, we can look at 3 Ohio Supreme Court cases.
Now, before you get into the argument, though, you're saying impose. Now, the judge pronounced the Tier 2 registration before he turned 21, right?
Yes.
It's simply a matter of the fact that that Tier 2 was inadvertently left off of a order. So are you saying the judge did not impose the Tier 2, even though she pronounced it orally?
That is correct. I'm saying she did not impose the Tier 2 because a court speaks through its journal entries, and because she did not put that in the journal entry on October 31st, then she did not impose it in a
Okay.
timely manner and lost jurisdiction.
When is his actual birthday?
His birthday was November 1st, 2022, so the day after the hearing and the day before the court put on the second non-pro-tunc entry that imposed the classification.
So if the court was going to correctly journalize within the time, it would have had to occur on October 31st?
Yes. And then also in terms of when the courts should have these hearings, the Fifth District in Ray JB talked about this. It's the state's onus to make sure we have these hearings, to have them timely, to make sure classification happens on time. So to give extra time, having this hearing on the last day certainly, doesn't give any time to do that. But when we look at these Ohio Supreme Court cases, In re AW was instructive on this timing of the entry, and that was about a adult SYO imposition, and because that entry in AW happened on that juvenile's 21st birthday, the Ohio Supreme Court determined that the juvenile court did not have jurisdiction to impose that adult sentence. Then we look at Jean Baptiste, which talked about the initial classification hearing, and the initial classification hearing and entry cannot happen after a juvenile turns 21. And then finally, we get to the Ohio Supreme Court's decision in RB, which relied on Jean Baptiste and said that not only the hearing, but also the entry imposing the classification has to happen before a juvenile turns 21 and before they finish their disposition.
Counsel, was this some kind of invited error? I understand that SD agreed to the Tier 2 classification, potentially to avoid the SYO invocation. And so, was this something that he potentially invited by not ensuring that it was properly journalized against him?
I don't believe this is an invited error because I think the expectation of the parties is that the entry was going to go on that day. And it wasn't until I think after we got out of court, we could see what the entry actually was. Had there been some issue about what happened on the October 31st with the classification that day, then that might have been an invited error, and we wouldn't have had an appeal in this case if it was simply the court putting on this Tier 2 classification on October 31st. But because this is all about whether the court had jurisdiction at the time that they issued that. So when we look at this November 2nd non-pro-tunc entry, they lost jurisdiction. It doesn't matter that SD agreed to a tier classification on October 31st. It doesn't matter that the court advised him of his registration requirements. It doesn't matter that the court considered this in deciding what to do with the adult SYO sentence. They did not have jurisdiction at the time to issue this initial classification entry after he turned 21 and after he finished his disposition.
And what's so troubling to me about this case is that, the cases that most of the cases you cited, they didn't even have the hearing. And here we had a hearing, and it looked like the judge specifically decided not to invoke the SYO portion because she was satisfied that he would have to register, so that was a huge motivating factor there. And simply by virtue of a mistake, he doesn't have to register.
And I agree that that's a concern that could be a concern for the court, but it's simply still a jurisdictional issue. Again, had the court had a hearing before, we wouldn't be in this position. But even though no case has specifically talked about this exact issue, we have then the Ohio Supreme Court's case that's talking about the hearing and the entry, not just the hearing itself have to happen before 21. And we can also look at the 11th District's case in Ray NZ, which talked about if there was some remand about the initial classification hearing, that's okay if that's not happening at the exact time of release because it's remand, as long as, again, the juvenile has not turned 21 to impose that classification.
And we're only here because it's an initial classification, because the case that went up to the Supreme Court, it came out of our court and was reversed, that was the final classification, and you can do that after the person turns 21.
Correct, and that's what in Ray RB from the Ohio Supreme Court
Right.
looked at the difference between the initial classification and the end of disposition. And as long as that initial classification hearing was timely and the entry was timely, then the end of disposition later could happen potentially after the age of 21.
And all we're talking about here is that the entry wasn't timely. That's all
Yes.
we have at issue here, is
Yes.
whether the entry was timely.
Yes.
Counsel, whose responsibility was it to verify that the entry correctly went on? Was it SD's, the prosecutors, the courts, no one's?
I mean, I think the onus is on the court. If the court speaks through its journal entry, it's for them to make sure that that entry is correct. And unfortunately, because we were running up against this clock for his, when he was turning 21, there wouldn't have been time to correct any kind of entry. And even though this was a non-pro-tunc, I know non-pro-tunc is supposed to revert back to the time of the entry, but even that doesn't salvage the classification here, because for several reasons. One is because there was no classification in that entry whatsoever. So if you take out this issue of beyond 21 and completing the disposition, there was nothing about classification. It wasn't as if he was 20, the court imposed a tier 3, it should have been a tier 2, did a non-pro-tunc to then correct it to the
What if that
correct
was, you're saying that the court couldn't do any kind of non-pro-tunc because he turned 21, right?
Yes.
So what if it was a wrong classification? What if it was a tier 3 and it was supposed to be a tier 2 and the judge wanted to fix it to the benefit of your client? Couldn't do it?
I don't think they could. I think an appeal would have to happen from that entry.
But there was no jurisdiction, so he's stuck as a tier 3 registrant?
If then what was informed at the time of the initial classification is different than what was in the entry, then that would be a basis to file an appeal.
But if,
It'd be the same.
but if the judge doesn't have jurisdiction to enter a non-pro-tunc to fix a mistake to the benefit of your client, right? I mean, you're saying that once he turns 21, the judge can't issue a non-pro-tunc, right?
Correct.
To correct anything to reflect what really happened.
Correct.
So if the judge accidentally classified your client as a tier 3 sex offender when he should have been a tier 2, she couldn't fix it later under your argument, right?
Again, this hasn't been litigated.
I'm just
I don't
asking
believe
for
that-
like
sure.
the practical effect of this.
Sure, and that's why I think these hearings should happen before the day before somebody turns 21.
So he would be stuck with a tier 3?
I think that would be a basis to appeal because
Okay.
it would be like a sentence of being different than what was told to you in open court and having a worse outcome of what was in the entry and an appeal happening from that. And certainly a number of appeals happen in regard to that issue. And I think in terms of this non-pro-tunc issue, we can also look at I think it's the 12th District's case in State v. Halsey that looked at, whether a non-pro-tunc can happen for an adult imposing an initial classification when one wasn't imposed at the time of sentencing for adult. And that case looked at the fact that this individual had completed their sentence. And so the non-pro-tunc couldn't happen at that point, despite the state's request and despite that person being orally told in court at the time of sentencing what your classification is going to be, since it was not included in that initial sentencing entry and that individual then completed their sentence. So the subsequent non-pro-tunc that the state was asking for in that case would have been void, and so the decision not to impose the non-pro-tunc was upheld by the 12th District. And finally, we look at whether or not the court had jurisdiction once the state filed notices of appeal. So the state's notices of appeal were to the October 31st entry. And an appeal is perfected by the filing of the appeal. And when an appeal is pending, a trial court cannot take some further action unless it is to aid in the appeal. And issuing these non-pro-tunc entries, imposing initial classification, were not to aid in the appeal that the state filed. And what happened was the state basically had a stack of the 4 case numbers, and at 1:41 p.m. on November 2nd, beginning with juvenile case number 19-5155, filed their notice of appeal. Well, at the same time, in case number 5152, at exactly 1:41 p.m., then the Court of Appeals issued the non-pro-tunc entry in the 1 case number. Then subsequently, between 306 and 307, they issued the 3 additional non-pro-tunc entries. So those very clearly did not happen before the state's filing of the notice of appeal. And I'd argue that even the initial one was at the same time that the set of all of these notices of appeal were being filed.
And you are at your time if you want to reserve 3 minutes.
Yes, I will reserve the remainder. Thank you.
Okay, thank you. Good morning.
Good morning, Your Honors. May it please the Court, Ms. Moss. This case is not about jurisdiction. This case is about what happened, memorializing what happened in the hearing. Now, defense counsel would like for you to ignore the hearing. They say the hearing doesn't matter. What he agreed to doesn't matter. What transpired at that hearing doesn't matter. It's just the entry. Well, the entry is only there to reflect what happened at the hearing. So I think that this is, a perfect case scenario of why the court has the nunc-pro-tunc option, is to correct the record to show what really occurred, what really transpired. This isn't about jurisdiction to put the entry on.
Don't they have to have jurisdiction? I mean, are there other situations that you can envision where the court loses jurisdiction, but then they can issue a nunc-pro-tunc to fix a mistake?
Well, I think what we can't ignore that this is in the context of sex offender registration. And over and over again, and then RB specifically, we have the Ohio Supreme Court acknowledging that there is special jurisdiction, ongoing jurisdiction, if you will, with regard to registration. So that kind of takes us out of the auspices of any other types of scenarios out there, because it's the intent that the juvenile court's jurisdiction, when it comes to registration, it expands beyond the age of 21.
Can RB be applied to this case?
I think within the context, yes, because what matters, and Your Honor pointed to that, all the case law, is that the hearing occurred prior to the age of 21, the initial classification hearing. And obviously there were a lot of moving parts here, trying to hold an involved hearing for a serious youthful offender specification, but at the same time being very mindful that we're under the gun here with the clock, and we've got to get this classification matter decided too. Very clear from the record. And again, that's why the hearing matters. It's not a jurisdictional issue with regard to the entry, because the entry is just, the purpose of the entry is to memorialize what occurred at the hearing. The hearing is what matters, and the hearing occurred in a timely manner, and regardless, he agreed to that tier 2 classification, and that's what that entry reflects.
Counsel, is this some kind of invited error situation?
I mean, to a certain degree, I think it's just kind of disingenuous at this stage to take the benefit from what he got, which was a very good benefit to him, and say, well, now what I agreed to, I don't even want to do that. It's kind of just reeks of, just not being a genuine of what occurred here. Again, given the nature of, what the court was faced with doing this, knowing that they had essentially one day to get through all of this.
And whose responsibility was it to ensure that this entry that came out on October 31st had the proper language in it?
Your Honor, if you could resolve that, I would be very. From my understanding, what occurs in juvenile court for entries is that it's just a matter of it's computerized, and it's checking things, and how that gets done. It's a mystery, but I certainly think that this scenario, it really, again, this is just to reflect what really occurred, to memorialize what really occurred. And I do like the analogy that's something I didn't think of, that this could have been the scenario where he was mistaken. They checked the box of tier 3 when he had agreed to tier 2. So it is it doesn't feel right that the court can't correct that to reflect what really the agreement was, what really occurred at the hearing, just because it occurred a couple days after his 21st birthday.
This is one thing that was left out of the order, but the order would have to be, under these circumstances, having the hearing on the very last day, your order would have to be precisely correct, no mistakes whatsoever, or else you're forever barred from being able to fix it. And that's troubling to me. I don't know how to reconcile that. And what you're trying to say is, well, sex offender registration is a special thing.
Yeah, in this scenario, I think we have that to fall back on.
Okay.
And I didn't brief that, but I think RB is very clear that the intent of the General Assembly when it comes to sex offender classification is that it does transpired, parts of it, not the initial hearing, which we
Right.
don't have to deal with here.
Right.
But the rest of it, it goes beyond the age of 21. So I think that sort of a saving grace in this scenario. That now, if we were talking about the court messing up the serious youthful offender language or something like that, which I'm sure they would be appealing that when, they meant to not
Right.
impose it, but they imposed it.
Right.
We'd be here in another, but I don't think that you could use the sex offender.
You
special-
couldn't, so that's the question, is if the court messes anything else up on the last day, the appellant's argument is we can never fix that.
Right, and I think that this should just be our classic textbook definition of what you use a nunc-pro-tunc order for, is to correct the written document to reflect what really occurred at the hearing, and that's what's important here. And that's, no one's asking this court to say anything else. We just rely on what a nunc-pro-tunc, the purpose of a nunc-pro-tunc order is.
Isn't the purpose of the entry to, especially in sex offender cases, to provide notice to the defendant of his duty to register and what that entails? And in this case, SD got that notice. He got it in the hearing. He just didn't get it in the written entry.
And he agreed to it.
And he agreed to it. So presumably he understood what he was agreeing to.
Correct. And I think that's well provided in the record. And with regard to the state's appeal, I'm sorry, I almost forgot about that. I think that, and again, what the state was appealing was not imposing the serious youthful offender. This did not at all involve anything to do with the classification. But again, the state's in us, and the one case that we cited to in response to this particular issue is that it's noteworthy is that the state has to ask leave to appeal in this scenario, and that was not provided. So the notice of appeal doesn't serve the same function as a regular notice of appeal if the juvenile had been, if he had filed that. So I think that takes us out of that realm. Unless there's any further questions, I will submit. Okay,
Thank you. Suppose you have 3 minutes.
This case, again, is about jurisdiction. It can only be about jurisdiction because it's only about what the court can do at the time that they issued that entry. There's all these other, things that have been talked about by the state, but none of that matters. It's just what happened at that time. Now, RB, while the Ohio Supreme Court looked at special circumstances for sex offenders, that was only about end of disposition, and they were so abundantly clear that initial classifications are different. And it's not just the hearing, but they specify that it was the order, the entry, that also has to happen before 21. So special circumstances don't exist for these initial classification hearings if those two pieces aren't met.
Ms. Moss, why was the timeline so compressed? When was the SYO invocation filed, and why did this classification hearing occur so late in the clock?
So I believe it was October 6th, so about 25 days before he turned 21, the state filed the motion to invoke the adult sentence, and there was no reference or indication or mention of initial classification hearing until the court hearing, I believe, on the 31st, on the day before he turned 21.
So there was not going to be a classification hearing at all until the SYO invocation was filed?
There was no mention of that. There was no filing. There was nothing in the transcripts about that happening.
So that was the triggering event that caused this to happen in the first place?
Correct.
And that was filed by the state?
So the triggering event of whether or not to impose the adult sentence was the triggering event that caused a hearing about whether or not he was going to be released, because the initial classification hearing is supposed to happen upon release, although there have been cases certainly that the hearing can happen before that time to ensure that you don't run into this situation. But this concern about having an entry and having it on the last day and not having any ability to correct that, the Ohio Supreme Court looked at that in In Re AW, where the court wanted to impose this adult sentence, and because the clerk didn't file it, even though the judge signed the entry and it wasn't filed, this adult sentence never happened. So kind of that analysis was already evaluated by the Ohio Supreme Court in saying that if things things aren't done correctly, when you're at this day before somebody turns 21 and it's not done correctly, then that is not a valid order and cannot be imposed on this juvenile. So for all of these reasons, we would ask that this court reverse the juvenile court's decision and vacate SD's classification. Thank you.
Thank you. Thank you both for your arguments this morning. The case is submitted and we'll issue a timely decision. All right, the last case today is State versus O'Neill. Mr. Cummings, would you like to reserve time?
Yes, five minutes, Your
5
Honor.
minutes? Okay.
Thank you. Your Honors, this is a very straightforward record case. To make things simple, let me refer the court to page 4 of the trial court's decision, and I think that's where this case went bad. In the first full paragraph, the last sentence, the court said that law enforcement cannot stop and investigate an individual seen with a concealed firearm in light of our CCW law. And that was the basis for her finding, basically. And from there, I think the case went downhill. At the time he was stopped, seeing a concealed weapon on somebody's person did give officers reasonable suspicion to investigate. That's State versus Moyer, for State versus Taylor. I have a cite to a district case that says the same thing. That did change a year later, but at the time this man was stopped, it did provide officers with the reasonable suspicion to detain Mr. O'Neill until they can investigate whether or not he was permitted to have one. In this case, before the car he was in was searched, they determined that he was under a disability, so he was not able to have a gun in any case. So the fact that he had been seen with a gun, they had followed him directly to this place where the car was stopped. There was no stop where the gun could have been disposed of. The gun had to still be in the car because it wasn't on the driver's person either. So
Just understanding the facts, though, this was not a traffic stop. The police didn't pull over the car for any reason. The car pulled over on its own, right?
correct.
And then he was standing outside of the car.
Right next to the car,
And
and that's
then-
where he was approached, yes.
So the officer goes up to him. You're saying because the officer believed that he had a concealed weapon illegally.
Well, because it was possible.
So it was possible it was illegal.
possibly-
He saw a gun handle
Correct,
and he thought, okay, I'm going to check and make sure he's got a permit.
exactly. And that's what makes this different than Rogers, which is
Right.
where you pointed out, it was a nondescript bulge. Well, in this
Right.
case, we actually have a gun. So this gave the officers reasonable suspicion. They had probable cause to search because they found out he was under a disability, but even if we didn't find out about the disability, I would still posit they could have done a protective sweep of the car while they investigated, pending investigation, because they knew there was a gun somewhere, and for their safety, they couldn't allow them to go back into the car without
Well,
finding that
counsel,
gun.
they didn't argue that below. I mean, the officer did not testify that he went into the car for his safety. He testified that he went into the car because he saw a marijuana cigarette in plain view through the tinted windows.
Correct, in part, the gun and the marijuana, that's true.
So aren't we stuck with what he said?
Well, no, I think what the officer did, he could be right for the wrong reason. Actually, he identified the correct reason. He was in search of the firearm, and that was appropriate. The marijuana, I fell into a red herring in this case myself. I failed to acknowledge, as my co-counsel pointed out, that the trial judge, I guess, in the companion case found that the officer's testimony about seeing the marijuana was not credible. So if that's the findings of fact that the judge made, I'm stuck with that. So I can't be up here arguing that the view of the marijuana justified going into the car. But I'm okay with that because it's my position we don't need that in this case. They could have done it as a protective sweep. They also had probable cause to search because they found out he was under a disability. So
So they can do a protective sweep of the car, even if they were standing outside of the car?
yes. Michigan versus Long, State versus Bobo, they say that if officers have a reasonable suspicion that somebody is possibly armed during a stop,
During a Terry stop.
and correct, then they can do a protective sweep of the passenger compartment of an automobile, and this can even occur at the end of the stop, because it's quite likely that at the end of the investigative detention, the people will be allowed back in the car, and they don't want these people to have access to a firearm even at the end of the stop. So the protective sweep can occur even at the end of the stop, and that's in State versus Bobo and Michigan versus Long. And that's to protect the officers. And if they don't do it in cases like this, that could be the last call they're sent on in their career, because these people can get back in the car, retrieve the firearm that was not searched for, and, be shot with it. So-
Counsel, I hear the arguments that you're raising, but these two arguments in particular were not raised by the state or the officer in his testimony below. And so the trial court didn't consider these two possible explanations for the car search. And so what do we do with that? I mean, the trial court was really focused on the chicken wing litter and the excessive window tint and the marijuana cigarette, because that's what the state was presenting as its case to justify getting into the car. And so we're not looking over a record that considers, for example, whether a protective sweep was necessary or whether evidence would have been found in the car and whether probable cause existed. How do we approach reviewing something that essentially didn't happen?
Well, because I think part of what you say I would disagree with. The trial court did acknowledge that the officers saw the gun. And the trial court did acknowledge on page 2 that that's why the officers wanted the car pulled over for detention, because of the observation of the gun. The court acknowledged that. The court did say that's why, in part, they were stopped, detained, and searched. The court went south when the court decided that just seeing the gun wasn't reasonable suspicion. That's where my point is. That's where the court made the disconnect, because that's an error as a matter of law.
Well, there's the people, and then there's the car, right? So, yes, I agree with you that the court talked about the gun in the context of seeing it on Mr. O'Neill.
Right.
And what role that played in the police approaching Mr. O'Neill himself as a person to begin with.
Correct.
But how do we separate that from the car and getting into the car? And
Well, you don't want to separate it. You want to look at the totality of circumstances. And contrary to my co-counsel's submission, the fact that O'Neill was not found to have the gun on him when he was searched does not dispel the suspicion. It just focuses it on as to where the gun must be. It must be in the car, because that's the only place he had been in that hadn't been searched yet. So the suspicion had not been dispelled. The totality of circumstances indicates that if the officer eliminates O'Neill's person and AD's person as the location of where the firearm is, it's got to be in that car. So the reasonable suspicion still leads them back to the car. You don't separate it. You take it as a totality of circumstances analysis.
so they're looking for evidence,
They're
essentially.
looking for the gun, which is the reason they were out there in the first place. Yes.
I believe Officer Mark testified, he said there was already the presence of illegal drugs, but there was the additional concern of a firearm.
Right.
So he did testify that
Yes,
it
yes.
was both, the marijuana cigarette, which the judge found a credibility issue with that.
Right.
But he did testify that there was the additional concern of a firearm that they were looking for.
Correct. I mean, he consistently mentioned the firearm. He got sidetracked on the marijuana, and so did the trial court, and so did I. But basically, the gun itself is the focus here, and that's what justifies everything.
Well, let me ask you this, Mr. Cummings, you didn't put this in your brief, but
Yes.
the prosecutor that argued the case in the trial court is arguing the automobile exception to the warrant requirement. And I've got the transcript here. I'm going to paraphrase it. And he's going through the reasons why the automobile exception applies. And the judge says, so I'm not familiar with the automobile exception to a warrantless search. Now, I understand that we're stuck with what the judge said about the marijuana cigarette, but it sounds like she was unaware that there was an exception to the warrant requirement concerning automobiles. but we do a de novo review, so are we permitted to consider that?
Oh, absolutely, because you have to accept her findings of fact, but you don't have to accept her conclusions of law, and I think that's what the de novo review contemplates. You're absolutely right, yes. Unless the court has other questions, I have nothing else.
Okay, thank you.
Thank you.
And you still have your rebuttal time.
Thank you.
Thank you. Ms. Nelson?
Good morning, Your Honors. Good morning, Mr. Cummings. May it please the Court, Sarah Nelson on behalf of the appellee, Mr. Adonis O'Neill. I'd like to begin by narrowing the focus of this case and what the reasonable suspicion actually pertains to, which is the unlawful possession of a firearm. Possession of a firearm alone is not illegal, and that's what the trial court was focused on in this case. It was a reasonable suspicion that the possession of a firearm was illegal. Was Mr. O'Neill illegally carrying a firearm?
Well, wouldn't you agree, though? I mean, when we talk about the stop, because we want to narrow this, there have been numerous courts. At the time of this particular case, you had to have a concealed weapon permit to carry a gun.
Yeah.
And there have been numerous courts that have held that an officer can stop somebody if they see, especially a handle of a gun, to determine whether they are legally allowed to carry it, right?
I would qualify that finding is normally in conjunction with other indicia of criminal activity, which we don't have in this case.
So you're saying that the cases cited by the state, such as Taylor, for example,
Yes.
there has to be other things going on besides the fact that they just saw a gun handle.
So I will acknowledge that in Taylor, the gun handle was a primary factor, but that officer in that case also testified to certain specific characteristics about what she saw to distinguish what she saw from something like a cell phone or a Walkman in the person's pocket.
She said she actually saw a gun, a handle, right?
Well,
in
the
that case?
concurrence also talks about in that case, though, that the handle was in the waistband and also covered by clothing. So there is testimony about seeing what she perceived to be a pistol in the front waistband of the person's clothing, but there was also testimony, as the majority cites, that they distinguished the observation from being a cell phone or something else. And we don't have similar testimony in this case to really focus in on the specificity. I know that there was a specific comment that they saw the handle of the firearm in the person's pocket,
Yeah,
but that was only when he was at the convenience store.
okay.
He gets in the car and then he goes to, and that's not necessarily illegal.
But the judge accepted that. I mean, she in her findings of fact, I mean, I didn't think it was disputed that the officer saw a handle of a gun sticking out.
Correct. All I'm
Okay.
trying to say is that the argument that was raised below in the motion to suppress and that was considered by the trial court is whether possession alone is
Right.
reasonable suspicion for illegal possession.
And
I
that
think
goes back
that's-
to my question of case after case that has said, and this is just under these particular circumstances where everybody agrees the officer saw a gun handle sticking out at that time because CCW was an affirmative defense, police could stop somebody to determine whether or not they're legally carrying. I mean, do you disagree with these cases, or are we to rule a different way?
All I'm saying is that I think this case is slightly distinguishable because of the lack of other factors that are considered in all of those cases. So like in Taylor, just the additional testimony about, there's several things in that case. I believe the officer observed that suspect for 5 minutes. We don't have a similar length of observation in this case. And in fact, the second time they saw him when he was out of the vehicle, there was no firearm. So that does raise question about the reasonableness of the possession alone. I know that we're all acknowledging that that's what the officer saw, but we're talking about possession of an illegal firearm, or I'm sorry, illegal possession of a firearm.
And that's the only reason why they're getting pulled, like they're getting stopped. In Taylor, that's the only reason, was because they wanted to see if he had, it wasn't because he was doing anything else that was suspicious, right?
He was not doing anything else
Right.
that was suspicious. So that raises the question, though, does possession alone necessarily trigger illegal possession? And when there's no other suggestion of him being engaged in nefarious activities, I think that that lessens the
The state
reasonableness.
here did add two other things. I mean, under this record, they attempted to argue, first of all, the officer testified that this was a, quote-unquote high crime area, that there had been shootings, robberies, and drug transactions in this area. So they added that to the calculus. And then they added this bit about the chicken wing, that they had seen him, littering under the Cincinnati Municipal Code because he discarded the chicken wing on the ground. So there was more that they contributed to their observations besides just the firearm.
So those were all asserted, I would agree, but the trial court found that the chicken wing observation was not an observation of a criminal offense. It wasn't littering, so that doesn't really factor into the analysis. There's no good faith argument raised by the state in this case to bring those back to the table. With respect to it being a high crime area known for shooting and drug activity, that's not specific to Mr. O'Neill and his possession at the time. It's very broad, and there's no indication that on this night in question that there was any sort of shooting or something that the police were heightened in terms of their need to investigate illegal possession, something like we saw in the Harrison case where they stopped. The Ohio Supreme Court found reasonable suspicion was met because of the immediate response to a shooting.
They also mentioned as well excessive window tinting and that they struggled to see through the windows to see the occupants of the car. So it was something else that Officer Mark testified contributed to his concern about the situation.
Well, that goes to the vehicle, and again, we're separating the two analyses here, which is reasonable suspicion to stop and search Mr. O'Neill, which is a separate consideration from the window tint. Going back to the case law discussion, though, I will say that even if the police could stop and investigate the presence of a firearm in Mr. O'Neill's person, at the time, reasonable suspicion is viewed from the time of the police encounter, which in this case, 2 officers had testified there was no gun anymore. They didn't know where it was.
I didn't quite get that argument. So they see a handle sticking out of his waistband. They conduct surveillance. You're saying that one, and then he gets in a car, and then he gets out of a car, and you're saying now the police don't have reasonable suspicion to Terry stop him because they don't see the gun sticking out of his waistband anymore?
Well, my argument is that there was no reasonable suspicion to stop him for the illegal possession. Now, if we're saying that it's okay for them to stop and investigate the potential possession,
Yeah.
I would say that that's as far as it goes. You can do a Terry pat-down to look to dispel that suspicion, and then once it's realized.
That's
yes.
what I'm interested in.
Sure.
Okay, so they stop him, they pat him down, there's no gun.
Over.
Okay.
Encounter should end.
Let me ask you this, so they asked for his identification, he gave it, they found out he was under disability, are they just supposed to disregard that and say, be on your way?
Well, in this case, Mr. O'Neill was in handcuffs, so we're beyond a consensual encounter. If this were a consensual interaction with the police, hey, what's your name? Can I have your information just to run a check? Different situation, but that's not what we have here. We have a full-blown detention.
At that point, it's a felony, though. If he is under, they found out that he's under a disability, and they think he has a gun. You're saying they're prohibited from searching that car? Is there a
Well,
prohibition? Or what is a prohibition?
On searching the car?
Yes.
Well, the basis to search the car in this case was because of the observation of the marijuana joint.
Well,
and-
I don't care about the marijuana, I don't care about the chicken bone. I'm more concerned about the gun. Is there any basis for the police to search the car at that point?
Well, I would disagree that we even get to the finding that he was under disability. We don't get to that question. That's evidence that's suppressed. That's an investigation that gets suppressed in this case because of the illegal seizure based on once again, even if we accept that the police can pat down Mr. O'Neill to find the firearm that they believe is on his person, once they dispel that suspicion, they don't get to go fishing for where that gun might be.
You don't think that there's probable cause has been developed that when they see him with a gun handle sticking out of his waistband, he gets into a car, gets out, they pat him down, no gun. Only logical explanation can be that the gun's still in the car. You don't think there's probable cause at that point? That the gun's in the car?
No, Your Honor, respectfully.
Why?
Because I don't think we have enough here to heighten the suspicion to a fair probability that a crime has been committed. So he has no gun on his person, then we're out of the realm of him presently illegally possessing. He's not possessing any firearm at this point. Sure, there's a question about, okay, well, did we see a gun? Where is it? We don't have enough facts here to heighten this of There's no additional criminal activity, no furtive movements, no suspicious behavior. He's not engaged in any.
He doesn't have it on his person. The police think it's in the car.
I'm saying that we don't have enough factors here to rise this suspicion of where is the firearm to a fair probability that something illegal is going to be in the car. In order to reach that heightened level of legality, we're talking about the unlawful investigation into his disability status. That's the only way that the police, separate from the marijuana, get into the car, is this offhanded, now we're also looking for additional evidence of this.
But if we find, like, let's just, I know you're saying the stop was illegal.
Mm-hmm.
Let's say the stop's fine, and the police can Terry stop him.
Uh-huh.
You're saying that they cannot, during the Terry stop, look into his background to determine that he doesn't have a CCW permit?
If the Terry frisk, the pat-down ends the moment that the police no longer have they've dispelled the suspicion of the firearm. Now,
Okay.
if he were not in handcuffs and this were a consensual encounter and Mr. O'Neill freely gave that information to the officer, like, here's my name, my identification, and then we have a different case. But he was in handcuffs, subject to an unlawful pat-down in our view. But even if the pat-down was considered a Terry frisk, then that's where it ends, and the police don't get to develop that information.
So they couldn't do the additional search of whether or not he had a permit?
Correct, unless it came under the guise of a consensual encounter with the police.
Okay.
And on that point, though, some of the other cases that the state cites to about the initial suspicion of a firearm, flight and consensual encounter sort of initiated the interaction, and then the defendant fled in the Moyer case. And that's what kind of led the police to having additional suspicion into
There's
the
no
presence
reason
of
to
a.
flee in this case.
I'm
There's
sorry?
no reason to flee if you don't have the gun, unless you have a warrant. Do you understand what I'm saying?
Well,
The gun
Mr.
wasn't on his person, so why would he flee?
I'm just saying, I'm talking about the consensual encounter. I was
Okay.
relating that fact back to the other cases, and I'm trying to distinguish why this case is a little bit different from cases where there was an observation of a firearm. There's also additional activity going on that kind of raises this level of suspicion.
Can I just ask, just so that I can get straight, if he had said immediately to the officer, I don't have a concealed carry permit, like say he just says it to him, and would the officer then have probable cause to believe that the gun is in the car? I mean, I'm just getting confused on, like, you're saying that they handcuffed him and they ran a check and found out he didn't have a CC. Let's just say he says to them, I don't have a CCW permit. And wouldn't it be, I mean, is there now probable cause to search the car because they saw him with a gun, he got in the car, he came out, they patted him down, there's no gun. Logically, it's in the car. I'm just trying to understand where you are in this logic.
Yep. So I'll just I'll just try and explain
Okay.
how I
Okay.
view the sequence of events.
Yes,
right?
please.
I'm going to gang up. I add the fact that the police ran the plate. There's no CCW attached to the car.
Sure, and in this case, Mr. O'Neill was not the driver, so
Right.
that's irrelevant as to his possession being unlawful. No, like the driver,
Okay.
the owner of the vehicle,
Right.
and that's what the trial court found in this case, and I think that's a reasonable finding.
Yeah.
But my argument here is that when we get to the point that Mr. O'Neill is patted down, that ends the Terry stop. Police can't go further than that.
Okay.
What comes after that is unlawful discovery of his disability status because it was not a consensual encounter. So we don't get to consider his disability status as it relates to the search of the vehicle. And I
Because
don't think,
we can't consider his disability status because you're saying the police couldn't do that.
yes,
That-
it was
that
proof of
running
an
of the
unlawful
information,
investigation.
okay.
Yes, that's our view.
Okay.
So then we get to probable cause to search the vehicle. Window tint doesn't get us inside the vehicle. Marijuana would get us inside the vehicle if the trial court found that to be credible. On your point earlier about the automobile exception, in the entry from the co-defendant's case, the trial court does do a very thorough analysis of the automobile exemption. So to the extent that
We can't get that. It's sealed.
it was, I believe it was made part of this record. It was
Was it?
ordered
Okay.
by this court. So in that entry, there's a very thorough discussion of the automobile exception. So to the extent that the court didn't go into that much detail, in this case, she did incorporate that previous entry into this case. So even though she might have said that at the hearing, she figured it out and understood that the only way to
Okay.
get in was based on probable cause. The probable cause in this case was the marijuana, which she found lacking in credibility, and this court accepts those findings of fact. So there's no probable cause.
But what you're saying is, like, after the pat down and they don't find a gun, you're saying we can't consider that they found out that he wasn't allowed to have a gun. So that goes out.
Yes.
And you're saying because we don't have that information and he doesn't have a gun, that means there's no probable cause that he illegally possessed a gun that could be in the car.
Yes.
Okay.
And that was the trial court's analysis. They said, there's no basis here to investigate further for the disability status. And I think that's reasonable under these circumstances. They dispelled the suspicion of him being in possession of an illegal firearm. And whether or not the police are fishing to find out whether or not it's in the vehicle, there are limits on how we get into the vehicle, which is where the marijuana comes into question. If that were a lawful observation, one that the trial court found credible, then the state certainly could get into the car based on that. But it wasn't a credible, factual circumstance in this case. For these reasons, I think in the circumstances of this case, I believe the trial court's analysis was thorough, and it doesn't conflict with the current state of the law, given the lack of additional heightened circumstances, like the lack of additional criminal activity. And although they didn't find the gun on Mr. O'Neill's person, that doesn't give police license to go find it, especially when at that moment, they're not even sure if it's an illegal possession that they're investigating.
Thank you.
Thank you.
Thank you.
Your Honor, I have nothing to add.
Nothing? Okay. Great, thank you. Thank you both for your arguments this morning. The case is submitted, and we will issue a timely decision. Have a good rest of your morning.